may proceed.
Can you please state your name for the jury?
Sure. I am Dr. Amy Klinger.
And Dr. Klinger, what do you do for a living?
I am the Director of Programs for the Educator School Safety Network.
Can you tell the jury about your education?
Sure. I have a bachelor's degree in education as well as a teaching license. I have a master's degree in curriculum and instruction, an education specialist degree, which is in reference to educational administration, which is another master's, and then I have a doctoral degree in educational administration.
And have you held any academic positions?
Yes, I was the chair as well as the director of the Educational Leadership Program at Ashland University, and I also was a full tenured professor there.
Explain to the jury what it takes to become a professor of education and administration at a university.
Well, you have to have a doctoral degree in the field of educational administration. You have to have experience as a practicing administrator, and then you have to have a particular research area or an area of expertise that you focus on.
Do you have any certifications or license?
I have a permanent teaching license. I have a gifted validation. I have a principal's license. And I also have a superintendent's license.
And the jury's heard about something called boots on the ground experience. I'm sure you're familiar with that term. Can you tell the jury about your boots on the ground experience in a school system?
Sure. Well, I started as a teacher. Then I worked in sort of quasi-administrative roles in central office as a testing coordinator and a gifted coordinator. Then I was a principal at the elementary and secondary levels. And at the university, in a university setting, I was the supervisor for administrative interns who were out in the field. And in my current position, we work directly with schools, providing training, going into the field, being in schools, working with them to assess critical safety concerns.
And so you're still providing boots on the ground work in school systems?
Yep, I'm in schools quite often.
Okay, and that's through your School Safety Network organization, correct? Could you just tell the jury just a little bit more about what that is and how long you've had that?
Sure.
And
I'm the co-founder of the Educator School Safety Network. We are a national nonprofit. We're a little bit unique in that we come from an educational perspective, not necessarily a security or law enforcement perspective. So we provide direct training and technical assistance and consulting to educators, both administrators as well as teachers and support staff and other school stakeholders. We also do vulnerability assessments where we help schools to determine potential vulnerabilities within the facility, but also within their protocols and procedures. We also do threat assessment training to help schools to develop threat assessment teams and to implement a threat assessment process. We also do research in the field of violent threats and incidents, and then finally we develop content. As a nonprofit, we want to be able to put resources in the hands of teachers, and so we make those available to them through some of our content development.
And have you been an instructor or a trainer for the Department of Homeland Security?
Yes, through the RDPC, I was working with FEMA and DHS to develop coursework and also as an instructor to teach it. So I co-authored the courses and then worked with other FEMA and DHS instructors to deliver them.
Have you published?
I have a book that I co-authored with my partner on school safety, and then I've also published a lot of professional journals as well as academic journals, newsletters, those sorts of things, as well as scholarly articles. And then we've also published our research. Every year we publish a research report for the previous school year.
Do you present on school safety issues, nationally or internationally?
Both. We do regional conferences, but mostly we do national ones, either related to professional organizations or related to specific topics. And then we have presented internationally as well.
Your Honor, at this time I would like to offer Dr. Amy Klinger as an expert in the field of education, administration, and school safety to testify regarding professional standards in this case.
All right, education, administration, and safety.
In school safety. School
Right.
safety, Your Honor.
Any objection?
No objection.
All right, so qualified.
Dr. Klinger, at my request, have you reviewed documents and information to determine if Dr. Parker failed to exercise any care or breached professional standards related to Ms. Zwerner on January 6, 2023?
Yes, I have.
Okay, Mr. Coleman, could you please publish to Dr. Klinger only the list of material that you reviewed? Let me know when you have it.
I have it.
Have it? Okay. So Dr. Klinger, didn't expect you to come in here and memorize everything that I've given you,
Good.
but could you just sort of educate the jury? There are different topics on the list, and you can do it by topic, of what have you reviewed to give your opinions to this jury in this case?
I reviewed videos, body cam footage from the sheriff's department, as well as school board interviews with people that were involved in the incident. I have reviewed the discovery materials, both from the plaintiff as well as from the defendant, as well as the forensic services, the witness statements and incident reports. I've also reviewed materials related specifically to Newport News schools in terms of their operations plans, their employee handbooks, those sort of things, both for the district as well as for Ridge Neck Elementary. I've also reviewed the depositions, all of the depositions that were taken from the various parties involved. I've reviewed the school records for the student, JT, and then in addition, I've reviewed some additional things in terms of the forensic interviews, some of the circuit court materials for that involve the aspects of the mom.
Okay. In a moment, we're going to get into your opinions, but before we do you agree to express only opinions you hold to a reasonable degree of educational and professional probability?
I do.
And having reviewed the materials, have you formed opinions regarding whether Dr. Parker failed to exercise any care or breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I have.
Okay, and before we get to those, I just want to make sure the jury understands. Were you retained to help educate the jury about the issues in this case? Is that your understanding?
Yes.
And as an expert in school administration and school safety, have you reviewed cases for lawyers before?
Yes, I have.
And approximately how many cases have you reviewed as an expert witness?
About 25. This isn't my full-time job. I have my work at the Educator School Safety Network, but I've done about 25 cases.
And do you agree to accept cases both for and against school administrators?
Yeah. Actually, the majority of the time I am working on behalf of the plaintiff, not the school.
And this is your first time testifying in front of a jury, isn't it?
It is.
Not your first time presenting, but your first time testifying in
Yes.
front of a jury. Since providing expert services takes away from your work in the school safety arena, do you charge for your time to review cases?
Yes, I do.
And how much do you charge to review records?
All right, we've got to slip in a break, but we'll hear more from this education expert on the stand who the defense hopes will help the jury see that this was not a foreseeable act and thus Parker isn't liable. Stay with us. Back to court in just a minute, but first an update out of Wisconsin in the bad boyfriend murder trial.
Defendant Matthew Paul is accused of murdering his on and off again girlfriend of 20 years, Stephanie Pavlans.
And earlier today, a computer forensics expert took the stand to talk about the deleted text messages that were on Stephanie's phone. Take a listen.
In March 17th and June 17th, 2022, there are 380 deleted messages. With this information, I'm not necessarily able to tell you what the context of any of those deleted messages were or what time they were deleted.
We will keep you updated on that trial throughout the day. But now we're going to head back to Virginia. We have been following this case out of Virginia. It's the testimony in the first grader shoots teacher civil trial.
Former Rich Neck Elementary School teacher Abby Zwerner is seeking millions in damages after a student shot her back in 2023.
This lawsuit claims negligence in preventing the shooting, alleging that former assistant principal Ebony Parker ignored several warnings that the student had a gun on campus.
The defense says that was something that was unforeseeable to this principal. Let's get back into the courtroom now. They have a witness on the stand they think will help get the jury to believe that. It's a school safety expert, Dr. Amy Klinger.
$350 an hour,
And how much are you charging to be here today to testify in court?
$500 an hour.
And have you ever met Dr. Parker?
No, I have not.
Now we'll get to your opinions. Dr. Klinger, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She did not.
And Dr. Parker, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker was indifferent to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She was not.
Dr. Klinger, I'd like for you to, if you can help me, educate the jury about the roles and responsibilities of an assistant principal. Could you describe for the jury the roles and responsibilities of an assistant principal in an elementary school?
Sure. It is just that, to assist, working with the principal, but also working with the staff. It is a very collaborative role. It is working in all aspects of school operation, the instructional program, the staff relations, the professional development of staff, the daily operations and management, including safety, as well as the operational community relations side of things, working with parents, working with students, student discipline, special education. Very similar to that of a principal, but in this particular case and in most job descriptions, for an assistant principal, it says assist with. So it is very much an assistance, collaborative sort of role.
Now, is school safety an area that the assistant principal assists with?
Definitely, yes.
Now, is an assistant principal the sole person responsible in a school for school safety?
Oh, absolutely not. No one is the sole person responsible for school safety. School safety is a collaborative endeavor. Every person who is in that organization has roles and responsibilities related to safety. Every single person, every staff member, students, administration, everyone that you would consider a school stakeholder has a very critical role in school safety, as well as responsibilities related to those roles.
And what is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or potential threat in the school?
I'm sorry, can you say that again?
What is the responsibility of a school administrator such as Dr. Parker with respect to assessing a safety concern or potential threat? What do they do first?
Well, they need to establish the credibility of the threat, and that is not something that can be done alone. That's where the collaboration that I'm talking about. It's really important for an administrator to get feedback and information and disclosures from the people who are closest to the event. A school administrator cannot be everywhere. They cannot see everything. School incidents, school safety concerns do not occur in a vacuum. The world continues to spin. Other things continue to happen. The school day progresses. So it may seem easy to go, well, here's a one thing. We need to do that. But school administration is sort of spinning plates where you have a lot of different things going on and you need to be able to prioritize. And one way to do that is to get input from the staff, to get good information, to assess the plausibility, the specificity of the threat, to look at the circumstances surrounding it, and to get good intelligence, if you will, from boots on the ground.
Okay. And who does the assistant principal look to get the primary information?
You look to the people closest to the event. 911 operators and emergency responders will tell you they want to talk to the person closest to the event. They want to talk to the person directly involved. And in this case, those people had the potential to be really good resources. You had Ms. Kovac, who was a veteran teacher who had an established relationship with the student, who had worked with that student on a quite frequent basis. You had Ms. Zwerner, who was in the classroom, knew the student, had the student every day, had eyes on the student, what the demeanor was, what the context was, what the behavior.
Okay, let's go ahead and bring in former Deputy Public Defender for LA County, Philip Dubé. Philip, okay, so we are listening to some testimony here. Was this a credible threat? What did she do? Did she do anything that she wasn't supposed to do? We're hearing that according to this particular witness, this expert witness, everything the assistant principal did was fine.
Exactly. And the goal, if I am accurately assessing this, is to show that at most she was just negligent as opposed to grossly negligent. If it was just mere, simple, ordinary negligence, then the 11th Amendment to our Constitution kicks in and provides for sovereign immunity as a state entity, meaning from civil liability, from civil damages. It's only when the failure to act, failure to perform, or otherwise remedy a situation rises to the level of wanton or gross sort of negligence does the veil, if you will, of sovereign immunity under the 11th Amendment give way. Virginia has what's called the State Tort Claims Act, and what it says is we will waive immunity for state actors, but only if you can show that the actor was grossly negligent. And I think at most that's all they can hope for right now, is that there was just mere simple negligence. And by the way, that's how all the higher up officials got ousted from the lawsuit. The superintendent, the Board of Education, the actual principal of the school, they showed that at most they were just negligent as opposed to wanton and reckless.
Yeah, that's a really good point. As we're watching the video, Philip, of the principal's reaction that day, which some people say doesn't look like she's overly concerned about everything that's happening. But Philip, a lot of people have questions about the mother. We're talking about all these different parties who may have been responsible. I want to take a look at an interview that the mother, Deja Taylor, gave before her case actually was resolved, her criminal case. And she was asked about whether or not the teacher who's sitting there in the courtroom, Abby Zwerner, had any issues as far as the son, whether this child had issues with her beforehand. Here's her response to that. This, again, is an ABC News interview back in May of 2023. Deja Taylor said he had started medication and he was meeting his goals academically. He actually really liked his teacher, Abby Zwerner. I will say that week he did come home and was talking a lot about how he was being ignored by Zwerner. The next day, he was trying to tell her something. She told him to sit down, and he threw up his hands and knocked the phone out of her hand on accident, and he got suspended. Then she was asked if she feels responsible, and she said, "That is my son. So I am, as a parent, obviously willing to take responsibility for him because he can't take responsibility for himself. I would truly like to apologize that out of the incident, she got hurt. We actually were starting to form a kind of relationship with me being in the classroom. She was really a bright person." Philip, were having the parent be there to try and avoid any issues, and that had just stopped happening because of that medication. Does that at all play a role in these jurors' mind when the mother is not there inside of the courtroom?
Well, the test is one of foreseeability. You know, did mom even ever foresee or otherwise contemplate that her kid would get a hold of a loaded gun and bring it into the classroom and start shooting up a teacher? That's the whole point. Was it really foreseeable? Just because a young kid, and we have special ed kids all over the country who are on hyperactivity type medication. They're on Adderall, they're on other types of sedatives and things like that to help them get calm and focused and grounded so they can study and get an education. But the question becomes, who on God's green earth would ever anticipate a 6-year-old bringing a gun to school? And I don't think mom thought that that would ever happen. Certainly the teachers didn't, nor did the administrators. The problem is that when everybody was finally on notice that the kid may have a gun, nobody did anything. I mean, if I were the school teacher and I'm not following, a standard operating procedure because I'm not an administrator or an assistant or a regular principal, I don't care. I'm grabbing that kid, I'm sitting him down, I'm pulling his bag, and I'm emptying it. If I violate that kid's constitutional rights, so be it. Let's go into court on the gun charge. You want to get it suppressed, get it suppressed. The good news is I live to tell. And unfortunately, everybody dropped the ball when they should have been grabbing that bag, going through it, rifling through it to seize that weapon. And nobody did it. And you know why? Because nobody ever believed it could possibly be true that a 6-year-old would have a loaded firearm at an elementary school. I've been practicing law for a lot of years, folks. I have never, ever, ever in my career had a kid that young ever have a loaded firearm at school. Ever.
Yeah. It speaks volumes.
It does. It does. I mean, we'll just have to see how this continues to play out. But that's what they're saying. We did not think this was a credible threat. But Philip, to your point, I mean, it seemed like there was something going on, and so maybe some action should have been taken. So we'll see how this plays out. Philip, thank you. We're going to squeeze in a quick break. When we come back, we'll have more of this case. The defense counsel's second witness on the stand.
Here you are, responsible for the lifelong torment of an entire family. Is that evil in your mind now? So now you've taken her mother's life, and you heroically step in to console her.
I knew it was wrong, but yeah, I still did it.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific, only on Court TV.
Let's go back to Virginia for more testimony in a civil trial we are watching connected to a lawsuit filed by a former elementary school teacher.
Abby Zwerner is suing former assistant principal Ebony Parker, seeking millions of dollars in damages after being shot by one of her students. She alleges that Parker ignored several warning signs about the student having a gun.
The plaintiff's case ended last week. Now we are in the defense case. And on the stand right now is a school safety expert for the defense, Dr. Amy Klinger.
Valuable resources that can provide information to assist in evaluating the nature of a potential school safety concern.
And our teachers and people in the immediate area, something called first line responders, is that a term that's used sometimes?
Yes, and they're first line responders. They are the people that can see it, that are experiencing it, that can provide context, a really critical context of what was said, what was the demeanor, how was the person acting, what did other people say, what sort of actions are being taken. And so those first line people provide really important intelligence for an administrator to evaluate the credibility and the appropriate course of action for a response.
And does every school safety concern require an immediate aggressive response from a school administrator?
School safety concerns require an appropriate response from an administrator in the sense that it does not necessarily have to be immediate, it does not necessarily have to be aggressive, and sometimes that can be counterproductive. So if you think about the feasibility of every time a person discloses something that we go to the nth degree and we're going to immediately lock down or we're going to immediately do some dramatic response, you would never have school. You would be clearing classrooms all day long. It would be impossible for a school to function. On the other hand, school administrators have a responsibility to balance those things, to be able to get intelligence and information and make informed decisions about what the most appropriate course of action. Because think of the nature of a school where everyone runs around totally in crisis all the time because every threat is being treated exactly the same, and we're going to DEFCON 5 on every single threat. That's not safety. That is constant panic. And it also actually can make the school less safe because people become numb to it. You get into a boy who cried wolf situation where people are going, well, it's just another one of those. It's just another one of those. So the appropriate response, a measured, appropriate analysis of the information and the situation is really critical to keep people safe.
And Dr. Klinger, can you tell the jury the factors that an assistant principal must rely on to assess the potential severity of a reported student behavioral issue?
Well, in terms of looking at trying to establish or analyze the potential problem, plausibility is a big one. How plausible is it that this thing could be occurring? And that really factors into the age. I mean, in this particular case, if you're discussing a potential weapon or something of concern at a high school or a middle school level, it is much more plausible that there is the potential there that a weapon could be present. When you're discussing the plausibility of a 6-year-old having access and ability to bring a weapon to school, clearly we know at that point it was unprecedented and certainly not as plausible as you would find. So clearly that's one issue. Specificity is another, of how specific is the threat. What exactly is being said? What exactly is being disclosed? What words, what terms are being used? And then there's the context surrounding it. And again, threat assessment teaches us that we need to have the context of in what manner, under what situation, what were the circumstances. All of that kind of information is really critical. And an administrator cannot get that because they're not a mind reader. They are not clairvoyant. They cannot be everywhere. The way to get that is to get that information from the people that are seeing it, experiencing it, talking about it, and getting those reports and being able to aggregate that information so you can look at how specific is this, how plausible is it, what's the context, how credible, how severe. And all of those things have to be taken into account in order to be able to have an appropriate response.
And you talked about the assistant principal assisting with a lot. Is the assistant principal in this role triaging information?
Yeah, it's very important to be able to, because again, as I said, this doesn't occur in a vacuum. So because an administrator cannot do everything, they have to rely on the capacities and the skills and the professional judgment and the input and the context from other staff members and other people with which they work. So it's really trying to aggregate those things together because you cannot make a decision totally and completely by yourself.
In your review of the material, you've told the jury what you've reviewed. Were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern on January 6th?
Objection. I think it's an improper opinion, Your Honor. Not an issue in this case as it relates to Ms. Kovac, and for the reasons I stated previously.
Ask your question again.
In reviewing the material, were there any actions taken by Ms. Kovac indicating that there was not a significant level of concern?
I'm going to overrule that.
Go ahead.
Well, Ms. Kovac was present when Ms. Zwerner indicated initially about some defiant behavior. Ms. Kovac was told by some students that there was a concern about JT.
Don't say what anything Ms. Kovac was told, but or just
I'm
what your
sorry.
understanding of what action she took based on what she.
Based on the review of the materials, sorry.
So yeah, you can't tell us what other people said, just that you
Right.
relied on that information.
So based on the review of the materials, information was given that there was a concern. Ms. Kovac did not go to Dr. Parker. She did not call a lockdown. She did not call security. She instead went to investigate and spoke with the student or interacted with the student. When the student did not reveal the book bag, did not allow for the book bag to be looked at, Ms. Kovac did not call a lockdown. She did not remove the book bag. She did not remove the student. She did not remove the other students. She stayed in the classroom and after a lesson left the classroom then to report to Dr. Parker that the book bag had not been looked at. She went to lunch, the students went to recess, she came back during recess to look at the book bag. She did not call a lockdown, she didn't call security, she didn't call Mr. Rawls.
We're just reciting the experiences of Ms. Kovac from the day. I don't think it's responsive to any particular question. And the only foundation this witness would have of any of this information is in fact hearsay.
Well, she's stating from her review of the records, and that's what we're allowing her to testify to, so I'm going to overrule that. You may continue.
After it was disclosed to Ms. Kovac that the item had potentially been moved from the book bag, she observed the student at recess. And when the student did not approach her, wouldn't come up to her.
Who is to blame? This expert is trying to answer that for this jury. We have to hit a break. We've reached the top of the hour. Our thanks to Philip Dubé for his analysis. More from the first grader shoots teacher civil trial after this.
And welcome back to Court TV Live. I'm Kelly Craft, in today for Ted Rollins, along with Julia Janae. And we are in Virginia this afternoon for the first grader shoots teacher civil trial.
Yeah, this is one where the plaintiff, Abby Zwerner, is suing her former assistant principal, Ebony Parker, for millions of dollars after Zwerner was shot back in January of 2023.
The lawsuit alleges that Parker ignored the 6-year-old's behavioral issues and failed to act on several warnings about him bringing a gun to school that day.
But the defense says this assistant principal is not liable, that she acted appropriately and that she could have never foreseen that a 6-year-old would actually be carrying a gun. On the stand now, we're getting you back in for more direct examination of a defense witness, Dr. Amy Klinger.
And was acting in a manner that could be perceived as suspicious. She did not remove the student, she didn't move the other students, she didn't disclose to immediately all that information to Dr. Parker, she did not bring security, and she did not respond in a way that would indicate there was an urgent or imminent problem at that point, and then returned to her work in testing.
In any of the material that you reviewed, did you see any information that would that indicated Ms. Kovac thought it was a toy gun?
Objection, Your Honor.
Ask the question again.
In reviewing the material, did you see any indication, and you've read the statements and whatnot, that there was a thought that it was just a toy gun with this 6-year-old?
Your Honor, I'll proffer, and I think counsel would proffer, the only basis would be a statement which you ruled is inadmissible. Backdoor.
All right, I'm going to sustain that objection based on a previous ruling.
Do you want to tell the jury anything else about what you observed or from the records about Ms. Kovac's actions that day? I didn't want to cut you off.
No, just that testing resumed. She resumed her job responsibilities, and she was the person that had that relationship with JT.
And in reviewing the material, were there any actions taken by Ms. Zwerner indicating there was not a significant level of concern?
Ms. Zwerner reported to Dr. Parker going to lunch, and then, based on my review of the materials, never spoke with Dr. Parker again. There are numerous disclosures or information in the materials that indicates she was given information from students about a concern that she...
Your Honor, this is exactly what you ruled upon.
Do you have a response?
We can move on from that. Just
All right.
talk about the actions of Ms. Werner with respect to what you understand from the material with respect to what was going on in the classroom and whatnot, and
Right.
going to play to
It
the.
has to be stricken if it's sustained.
All right, I'm sorry, was that her moving on, or?
The statements
last
before,
statement.
the last statements that were objected to, if it's
All right.
sustained.
Yeah, they're stricken from the record, just like we talked about. If I strike something, you can't consider it. All right, go ahead and ask your next question.
Dr. Klinger, what is the material that you've reviewed? What actions did Ms. Werner take in the classroom once receiving information from Ms. Kovac about what other students were saying?
Well, instruction went on. The student remained in the classroom. Even though previously the materials indicate that security had been called in the past, that Mr. Rawls had been asked to assist in the past, none of that assistance was requested. No reports were made to Dr. Parker. The school day went on. The student went to recess. The first grade teachers, one of whom was Ms. Werner, observed the student, reported suspicious behavior to each other or texting it to Ms. Kovac, did not report that to Dr. Parker, did not clear the playground, did not remove the student, did not take the book bag, did not remove the other students. And so there's a lot of different opportunities for, and a lot of resources available for assistance that we know were employed in the past.
And did you see any actions taken by Ms. West indicating that she did not feel that it was a significant level of concern?
Objection, Your Honor, as to what she felt.
Sustain that.
Or indicated that there was not a significant level of concern? Same question I'd asked before.
Same objection before. I think the Freudian slip indicates what is being intended for.
Well, obviously, I'll disregard the previous recitation of that question and allow the second one.
I'm asking it the same way I did before with Ms. Werner, indicating that, did you see in the material any actions taken by Ms. West indicating there was not a significant level of concern?
Ms. West took a student, a different student who had a disciplinary behavioral issue, to Dr. Parker during recess and did not make any discussion of what was observed at recess, the suspicious behavior, those different behaviors that were being observed at that point. She asked Ms. Werner to watch her class and bring them in, so that doubled the size of the number of students that Ms. Werner was supposed to be supervising, which would indicate she felt that was appropriate to do, to ask her to do that.
Objection, Your Honor. Same thing.
All right. Overruled. Continue.
Anything else
No.
with Ms. West? Did you, in your material that you reviewed, you read the deposition testimony, see anything to indicate that Ms. West actually encountered Dr. Parker in the building?
She brought a student to, a different student that had disciplinary concerns to Dr. Parker and was involved in a face-to-face discussion with her, but that discussion did not include any disclosures about the behaviors of JT at recess.
And is that something you would have expected if there was a significant level of concern, that there had been a discussion at that time?
Yeah, I think it's important that this was an evolving situation, and one critical element is to get updates on what's happening, what's going on, what has changed, if anything, and those updates were not occurring.
And same with Mr. Rawls. So you've read all the deposition testimony and the statements of Mr. Rawls and whatnot. And is there anything, any actions taken by Mr. Rawls indicating that there was not a significant level of concern?
When Mr. Rawls spoke with the student R after recess, he received information, more information about JT, and again, did not feel that it was necessary
Objection,
to.
Your Honor. Did not feel.
Sorry.
You could just say what he did not do.
He did not remove the student. He did not clear the classroom. He did not call security, call for assistance, call a lockdown. All of those things are capabilities and resources that were present to any of these individuals.
And in the material review, did you see that at some point there was a discussion between Dr. Parker and Mr. Rawls about body searching the student? And do you have, what is your understanding about decisions made in that regard?
Generally, or in this specific?
In this specific case?
There
Without
was
saying what someone said.
There was a discussion about an option for a search of the student, and the approach was cautious, as it would be appropriate to do so. And there was a determination made that when the parent was present, that search could continue.
Okay. And why would it be, in your experience, that a search of a student is something that could be cautious if you're looking for a weapon?
Well, we should always be concerned about the search of a student, regardless of their age. But certainly, and that is not something that any school administrator should enter into lightly. But I think it's really important to think about, this is a 6-year-old, this is a little kid, and we are going to do just at will start doing body searches on kids. That's not any kind of endeavor that anyone should do, especially when they don't have a good amount of intelligence or information that would support that at that point.
Dr. Klinger, do you have any opinion on whether Dr. Parker could have foreseen JT's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that. I think the actions of everyone involved indicate that they were doing an analysis, but yet that they did not perceive this to be a plausible, imminent threat, both the behaviors as well as the actions, because it is a 6-year-old having access to a weapon and bringing it to school, and it is largely unthinkable and certainly unprecedented in terms of the outcome.
And Dr. Klinger, did you review any protocols of the Newport News school system in your review of the materials?
The crisis plan for Newport News, yes.
And did your review of any protocol change your opinions in the case in any way about assessing the threat or the school safety concern?
No, the protocols of a crisis plan provide a framework. They provide guidelines for what people should be doing. But they also have to, and in this particular case, they give people latitude for professional judgment. When a crisis plan becomes so prescriptive that you must do this, you must do this, you must do this, it really makes it actually more ineffective. So it is critical that people have the ability to use the tools that we've talked about and that use the judgment that we've talked about and incorporate or factor in the circumstances that we've talked about when they're making that decision.
And Dr. Klinger, are all of your opinions and conclusions you've provided to the jury today held within a reasonable degree of educational and professional probability?
Yes.
Please answer any questions Mr. Beniozen has.
Cross-examination?
Yes, Your Honor.
That wraps up the direct examination, where this expert says this simply was not foreseeable by the principal. Let's bring in our guest for this hour to discuss. Joining us from California, we have civil rights and trial attorney Joe Richardson. Joe, glad to get your thoughts on this, especially from what we're hearing come up in the direct examination, this issue of the difficulty for teachers in not wanting to violate perhaps the constitutional and civil rights of this student, because it is a body search at this point where the student would have to be searched. What are your thoughts on just whether these jurors are going to think that it was okay to not go forward with that?
I think there's an argument that this testimony is compelling. I mean, fundamentally, how do you foresee something that's never happened before, right? And now this expert is saying, what do you do in the meantime to stay safe? She kind of suggests almost a pragmatism. She says something to the effect that you can't have an overly aggressive response. It can actually be counterproductive. There might be something to that. However, this is a particular instance where you kind of know that you've got problems with this particular kid. There are some things that happened even a couple of days before our plaintiff acted differently under a different circumstance with this same kid. So do you graduate into that foreseeability area? And it's an interesting question, but it presents the difficulties that I think the plaintiff may have. They still have the one defendant, but they've lost all of these other individual defendants for kind of similar reasons. Where can you see this going? And the expert says she's the assistant principal. So her job is to assist. It's almost like she doesn't lead on anything. She assists, she helps, etc. So why does she stand in the front and suddenly do a body search, suddenly go through information when you have constitutional rights, etc.? And it presents some interesting questions.
Joe, where do you think the plaintiff's attorney will go on cross? You mentioned a few areas. Talking about the student had some prior incidents in the past. And I mean, even just in general, there are school shootings. It's so prevalent these days to have school shootings, unfortunately. I mean, I do believe it is foreseeable that this can happen anywhere, no matter the age.
Right, yeah. What you suggest is that the facts may be very specific, but was this completely and totally out of the realm of every possibility? And did you have information that graduates it from this thing that's super unlikely to happen to likely enough to graduate into foreseeability? I think that I don't know that you attack her competence per se. I think she's fairly likable. So you've got to kind of sideswipe her a bit. You've got to get her to acknowledge there's X number of school shootings. This type of thing happens all the time. This kid has shown some violent tendencies, etc. And fundamentally, if she can't foreclose every potential possibility, there's this suggestion she makes that I think that you can undermine, that the assistant principal, because she's assistant principal, could almost never be responsible, and therefore she gets off here. And that can border on the ridiculous.